Bryan, good morning, and thank you again for taking time out of your Friday to join us and to present to us what is always a very interesting topic. Over to you.
Good. Thanks very much, David, and thanks very much, everybody, for joining us this morning. Yeah, as David mentioned, I want to be a bit different today. What I proposing or what we're looking at doing is I'll start with just some general overviews and comments about estate planning, the value, the need, what it means or what it looks like. But then what I want to do is go through from a practical point of view when, as advisors, you are out there seeing clients, going through the issues and going through, we've got 5 scenarios, and depending on how time goes this morning, we'll go through these 5 different scenarios, just looking at these scenarios, and realistically these could be your clients because we've got the different stages, the different life cycles, from a young single person through to married, through to divorce, through to business. So what we're looking at are the relevant life journeys or the stages that clients go through, and from an estate planning perspective, what are the issues, what are the speed humps or the roadblocks, and from a practical point of view, what as advisors you need to be aware of, that those situations that do occur in your client's life and where you can add real value to your clients by saying, hey, from an estate planning perspective, there's a possible risk, there's a possible issue here, but I would put a caveat on it. The intent of today is not to turn you into estate planning experts, but to give you enough information, enough knowledge so that you, when you're with your clients, can see those issues and then provide that extra value to your clients and saying, hey, from an estate planning perspective, potentially there's an issue, there's a ramification or the consequence of what's happened. I need, or I would recommend to you that you get the appropriate advice. So the first session, we just want a bit of an overview of estate planning, what it is about, what it looks like, why it is relevant to every client that you do have. So as we say here, it is planning for the inevitable. It's the old adage, we don't plan to fail, but we fail to plan. So as advisors, be it risk advisors, mortgage advisors, investment advisors, you're out there providing advice. You're providing protection. You're providing that certainty or the comfort for clients so that they can, all other things being equal, go forward knowing that they are protected, that they have got the right protection in place so that if the unfortunate or the inevitable does happen, then they are covered. But what basis or what foundation is all that advice, that protection or that support founded on? And this is where estate planning, I see it as the foundations, because unless you have that solid, structured foundation, then potentially the advice or the protection that you have put in place for your clients could potentially come crumbling down because the ownership may not be correct. The asset may be at risk from potential relationship failure, potential business failure. So it's about those what-if scenarios in that. So to extent, we are looking at creating or crystal ball gazing, so we have consideration for the possible, because unfortunately the worst case scenario might happen. So what would the consequences be to the client if that unfortunate circumstance does occur? What protection from an estate planning point of view do they have? So we're looking at ensuring that what the client wants to achieve, so they've got their intended objective, but is the roadmap or is the course that they have set out on from a estate planning point of view going to ensure that the protection or the benefit that you as advisors are providing will be achieved? So we are looking at reducing the risk, looking at potential challenges and where possible reducing the risk from those challenges, but also from a complexity point of view, looking at having it as simple as possible based on the circumstances. So it's very much about a holistic approach in obtaining from the client or understanding from the client what are they trying to achieve, what is their desired outcome of the assets. So if anything should happen, be it death, be it incapacity, be it business failure, be it relationship failure, what would happen if something does go wrong? So those what if scenarios are covered and that the assets are protected. We're also looking at, and this is probably becoming more prevalent with clients that we see now, the next generation. Mum and dad or the individual has worked hard or has achieved the desired outcome or obtained or acquired those assets. They're concerned about the succession for the next generation. So what happens if the client passes away tomorrow? Suddenly the son, the daughter, or that next generation inherits that wealth. What are they going to do with that wealth? Are they in a position to ensure that that wealth is protected? So it's about looking at future proofing or risk protection from an estate or from an asset point of view, those assets the clients do own. So clearly from a product point of view, and we won't talk too much about specific products today, but it's about the wills, the enduring powers of attorney. It's about family trusts, what is appropriate for the clients based on their circumstances. So from your perspective, what value do you add? How do you assist your clients to, as I say there, get it right? What we're talking about here is the value that as advisors you do provide for your client. Because with due respect, as advisors, you do go that extra distance. You do go and see the client, sit down with them, go through their circumstances and have a holistic approach to them. So you know the client. You do, and I, especially from our industry, acknowledge that there is a ability and a privileged position that we do have where we are told things from a client. We are, for want of a word, in the inner sanctum and know their warts and all circumstances and that. So estate planning is ensuring that that weakest link is not broken, i.e. that the protection that you've put in place, it isn't undermined by a lack of planning from an estate planning perspective in that. Looking at that next bullet point, the majority of New Zealanders aren't sorted. They don't have their estate planning in order. Statistically, 50% of New Zealanders either don't have a will or that the will that they have is not current or not up to date. So there is a gap there that needs to be filled, and this is where from an advisor's perspective you are able to add that value or to enable that the gap is filled. We talk about planning for the client rather than for the portfolio. So what we're talking about there is ensuring that the client is center of the spectrum or is the nub of the wheel from which the tentacles of advice is or goes. So for example, you've got your specialist advisors that provide advice to your client. Maybe it's estate planning, it could be legal, it could be accounting, plus, and most importantly, it's the advisor who is providing that advice about risk, about investment, mortgage, whatever it might be. So from an advisor's perspective, you're ensuring that the clients are A, identifying their goals and objectives, and B, ensuring that they are, from a holistic point of view, all encompassed in the advice process. And probably from a client retention or a succession planning point of view, if you have the opportunity to sit down with your client and from an estate planning point of view, involve that next generation. So for example, if you have an investment client or a life risk client, they want to include the next generation so that the conversation, it's the round table conversation with the client and their children or grandchildren, as the case may be. If something should happen to your client, you already have an introduction to that son, to the daughter, to that next generation, so that when advice time comes for them, they already have the relationship with you, with the advisor, so they know or are more inclined to come to somebody that they trust and have had knowledge and a working relationship with. So that would be you, the advisor. So from a process point of view, what is best practice for an advisor? What does good practice management around estate planning look like? So that first bullet point there, is it raised in your client questionnaire and the ongoing annual review process? The classic example is a client comes back to you for review of their risk insurance or their investment, or they're looking at a purchase of another property in that. Have you asked them whether their relationship has changed? Do they have additional children? Or if they come in and want to change the ownership of a term life policy, for example, if it's currently owned by them as the individual, you know that under their will they have left the proceeds of that policy to a specific charity or organisation that they have an affinity with. They then come in and say, oh, I've got married now, or I want to change the ownership of that policy. Are you in a position to say, hey, that's fine, but from an estate planning point of view, are you aware that this will have a consequence on your will? Is that not an opportunity for you to then say to them, if you do this and change it from an individual ownership to joint ownership, that then defeats the purpose or the intent under the will? Is it not therefore appropriate to look at a further insurance policy to provide for the spouse or next of kin in addition to that other bequest or charitable intent that the client may have had? So it's about reviewing, ensuring that from an estate planning point of view, you are aware of the client's objectives, of their intentions. With respect to living insurance, I would suggest that it's best practice that if you are selling living insurance, that you have a copy of your client's property enduring power of attorney, so that if at claim time, the client or the family or next of kin come to you as the advisor and say, hey, mum, dad, or the individual has suffered an illness, incapacity, we need to trigger this policy. Who is going to sign that claim form at that trigger event time? If the client can't do so, or if it's a joint policy and it requires signatures of both policy owners, if one can't sign, how is that claim going to proceed? How will you as the advisor feel if you've gone through and done all the right thing by the client, have the insurance or have the protection in place, but then suddenly come claim time, that claim can't proceed because the insurance company require the signature of the owner, that owner is incapacitated, they can't complete the claim form, the insurance company, all other things being equal, can't proceed with the claim because the claim form can't be completed. So how, as an advisor, do you protect yourself, let alone ensuring that the client has certainty at claim time that all other things being equal, that claim will proceed? So it's about ensuring that you are adding the value that you can by having copies of estate planning documents held on your file, either in hard copy or in soft copy. And yes, I acknowledge that from a privacy point of view, you'll need to get the client to give this to you or get consent from the client for this. But isn't that better than not having confirmation or not having knowledge of A, who you're going to be dealing with if through circumstances something happens to the client, but B, ensuring that if something does happen to your client, you aren't faced with that awkward situation or that hard conversation with the family or next of kin of saying, yes, there is a policy in place, but unfortunately it can't proceed because we don't have a property enduring power of attorney, or unfortunately there will be delayed because there's no will, and we're now looking at the rules of intestacy as to who will get the estate and how it will apply. So what I'm suggesting is that as an advisor, again, it's not about you providing the advice, but it's about providing or being the facilitator to ensure that the advice is available to the client and that you have those appropriate relationships or providers that can help you or assist you when you're dealing with your clients. Okay, so from my point of view, this is where I get lazy. It's Friday and I don't want to talk for a full hour. So what we're looking at doing today is working through 5 case studies. So what you'll see on your screen now is our first case study. So what we're looking at from your point of view, and this is where I'll get you to think about this situation. When you have, then via the chat box or the question and answers, flick through to David your thoughts, your ideas about the estate planning issues that you see or you perceive for your client. So this example that you've got on your screen now, this is your client. So she is a single person. She has a KiwiSaver balance of $17,000. She has a group life cover through her employer. She's planning to travel. She has parents, but unfortunately they are separated. She has replacement income insurance, and she's just purchased her first home. So if you could just for the next minute or two, send through to David, as I say, via the chat box or the question and answers, your thoughts or your issues that you can see for your client from an estate planning perspective. We're not worried about solutions. We'll talk about the solutions shortly. But if this was your client, what red flags or what issues would you see for your client from an estate planning point of view? So just again, her circumstances, single lady, KiwiSaver balance of $17,000, group life cover through her employer. She's off on the OE, has separated parents, has a replacement income policy through you, and is also just arranged through your mortgage company to purchase her first home. So in the next minute or so, if you could just flick your thoughts about the issues that you see for your client through to David.
Okay, hopefully that made sense. If you're not sure where those are, and it's in your Zoom control panel, there is a Q&A session and there's a chat session. Or a chat box that you can use. If you post stuff there, I'll be able to read it, and I'll share it with Bryan.
So just to reiterate, we're not worrying about solutions or answers. This is just you as an advisor meeting for the annual review with your client. She's presented herself to you with her current updated circumstances, which are, as we've just discussed in that. Yeah.
Okay, I think we've got... everybody seems to have gone to sleep. Okay. Brent Lewis asked or mentioned that there's probably no will or EPA in place. Is there any, I guess the sort of questions that you probably want to ask is what would happen to her if she was overseas and became incapacitated in some way, shape or form, or was, well, God forbid, she was killed. Yeah. What would happen then?
Yep. The other thing to think about, and I know it's a bit of a red herring, but that point there where I say separated parents, just think about that. If something did happen to her, would she want it to go to her separated, to both parents? How can she ensure that it might go to one or to both or to neither? Or does she have an obligation to her parents in that? Should I move on, David, to the...
So we've got a couple of other points. Michael's mentioned that she would need travel insurance, which makes absolute sense.
Yeah.
Right Heart saying chat's not working. I've got a couple coming through from chat, Rod. I'm not sure why that is.
Okay.
Life support issues from Michael Cave. So yeah, potentially. I mean, if she's incapacitated, then life support could be life support. If she needs to sign something, then she might need some sort of EPA in place, I'm guessing.
Yeah. Yep.
It mentions she's got group life cover through her employment, but presumably that may not continue beyond her if she decides to do OE.
If she goes travelling in that, yeah.
Yeah.
Yep. Okay, so if we then look, so these are the facts. So as far as the issues, and yeah, as David has pointed out, a number of you have identified them in that. So yeah, that first point, forget the name of the person who mentioned it, David, but yeah, if there's no will, the Administration Act will apply to deal with the estate. So again, coming back to her scenario, she's single, she's got parents, they're separated. Without a will, it will go automatically to her two parents. Is that what she wanted? She may be, and I'm not suggesting that it is the case, but there may be a situation where one parent may either through circumstances not be appropriate to leave it to, or she may not want it to, but unless she has a will, it will automatically go to her two parents equally. Again, is that what she wanted? What about her siblings? She may have a brother or sister that she wants to refer or leave funds to. Without a will, they will miss out. So yeah, certainly she needs a will. Traveling, and again, David's picked up this point. She's off overseas on a trip. What happens if something crops up back here in New Zealand? The investment portfolio or the property, she decides to sell the property, she needs the money, or for whatever reason, who's going to sign on her behalf? So the message is here that a young person needs an enduring power of attorney as well or as much as an old person like me needs it. I'm more likely to become incapacitated or have dementia or do stupid things, whereas a young person, you know, they are off on their OEs, they're off travelling, they're off seeing the world and exploring things. The example I use is the client we had here in Auckland a year ago. Excuse me, her daughter was in Paris at the time of the Paris bombings. Unfortunately, she couldn't access her bank account in Paris through electronic means. She was able to email back home to mum and to her bank back here in New Zealand. She requested the bank release funds into mum's account so that mum could get it across to her. The bank unfortunately said no. Without an enduring power of attorney, they were not able or not prepared to release funds to mum, but they did offer a solution to mum, which was to give mum a facility, a personal loan, and charge mum a very kind and considerate rate of 22%. So these are the sort of things that could potentially happen. And especially, as I say, with young people that are travelling, circumstances change, they need access, they need to look at their assets, who's going to step in and act for them. We talked before about parents. If this young person's parents were unfortunately to pass away, should the parents leave their estate to the daughter? I would suggest that mum and dad shouldn't leave the estate to the daughter. Why? Potentially the daughter going forward could be looking at relationship issues, could be looking at business issues. So is it not appropriate for the daughter, through your advice or your input through your relationship with an estate planner, suggest to the daughter that she has a conversation with mum and dad and say, hey, mum and dad, don't leave me anything, don't leave your estate to me. What I would suggest is that it's appropriate for an inheritance trust to be established by mum or by mum and dad, so that under their wills, they don't leave it to the daughter, but they leave it to a trust that they have created for the daughter, so that they are future-proofing the inheritance for the daughter, so that if she does get into potential new relationships or businesses that may have a risk associated with them, she doesn't stand or doesn't get into a position whereby potentially she could lose that inheritance in that. Yeah. And again, that next bullet point, she could meet up with a foreigner, be it a nice Italian man or a European man on her trip. She's got an asset back here in New Zealand. She decides that it is appropriate to come back to New Zealand with this new partner. He's around for 3.5 years. He walks out. He claims half of the house which she has already purchased. That becomes relationship property. She potentially is at risk from that new relationship. So it's appropriate for her to consider the establishment of a trust. So these are the sort of issues which this client of yours is facing. So although on the face of it, she's straightforward, uncomplicated, good client, she still has estate planning issues. So as far as solutions, and this is what we've been talking about, look at getting the will put in place. Look at the enduring power of attorney. So again, she's not too young, or her circumstances are such that it is appropriate for her to have the enduring power of attorney. Again, going back to her situation, she has replacement income insurance. If there was an accident, she was on a scooter in the Greek islands, come off and ended up being incapacitated, or something happened to her, who was going to complete that replacement income insurance? Or if there was a TPD claim or any form of living insurance claim, if she didn't have the enduring power of attorney, who would complete that for her? So she does need to look at the enduring power of attorney. Establishment of a trust. Sorry, David.
Just a quick question, Bryan.
Yeah.
Michael's asked, what documents would be needed if she ended up in hospital and has long-term care issues? For example, 6 months.
Yeah, because so if she was in hospital, both personal care and welfare enduring power of attorney and property enduring power of attorney. So, for example, if there was consent required for standard medical procedure, who's going to sign the authority to the surgeon or the hospital to proceed with that? Unless there is a personal care and welfare attorney in place, nobody has the authority to give consent for that standard medical procedure. Yes, if it's life-threatening, then the hospitals or the authorities can proceed. But for example, she's in a coma, she'll eventually come round, but in the meantime, they want to fix the broken arm or the broken leg or that standard medical procedure, who's going to give consent? If she does have the property back here, or she owns the property in here, she wants to change the mortgage documentation, for example, new rates have come out, interest rates have gone down, she wants to alter or amend or adjust it, who's going to sign on her behalf? Or she has a property that she wants to change the fire and general insurance on it. It needs the signature or needs her signature. Again, a lot of institutions or organisations require the original documentation. They won't accept a scanned copy unless they have unless there's an enduring power of attorney back here in place in New Zealand who will sign on her behalf.
Okay, thanks, Bryan.
Cool. And then, as we talked about before, mum and dad, look at the establishment of the inheritance trust. So rather than mum and dad leaving the estate to the daughter, have the parents considered the appropriateness of creating a trust? And yes, unfortunately, it may be the good old mum and dad bank that pay for it, but the establishment of a trust whereby under their wills, they don't leave the estate to the daughter, they in fact leave it to the daughter's trust that they have created. And it could be one trust that they are both party to, or potentially it could be two inheritance trusts, because unfortunately mum wants to set up a trust separate from dad's because of their acrimonious situation. So be it. But it's about ensuring that the inheritance or the protection for the daughter is protected by way of a trust. Okay, so that's your first client. So if we then look at the next scenario, so your client has now popped back in to see you. It's like 3 or 4 years down the track. So your clients, Bill and Mary, they are now engaged. They have set the wedding date for 3 months' time. They have assets which they have disclosed to you or which you are privy of that they own both individually, so they have individual assets, but they also have jointly owned assets. And both Bill and Mary have elderly parents. So again, what we're looking for from you to refer through to David through the chat box or your question and answers, what estate planning issues can you see, or what red flags potentially are there here for your clients that present to you with this circumstance? So your clients, Bill and Mary, they're engaged, they're looking at getting married in 3 months' time, the assets that they have are both individually owned and jointly owned, and they both have elderly parents. So for the next minute or so, if you could just, same as what we did previously, just flick through to David via the chat box or the question and answers, what you see as the potential issues from an estate planning perspective for Bill and Mary, your clients.
So Colin's immediate response is go and see a lawyer.
Yes. Or we might like to rephrase that. Get advice. Is that what they were saying, David?
I suspect that's probably,
Yeah. So I meant to say, are the question box and chat box working okay, David? So you mentioned before that it was...
I think Rod had an issue with the chat box, but I'm not sure whether he's still having that issue. Others have managed to post through the chat box. So.
And so I also meant to say, when I was going through the first scenario, if you have any comments, questions, or challenges to me on my suggestions or my thoughts, please send them through, and David can convey them through to me, and we can, via David, I can answer those for you as well. Sorry, I meant to say that before.
Right. Okay. Carol, you've raised your hand, so I'm going to quickly promote you to panelist, Carol, so you can speak. Carol, can you hear us? Carol, can you hear us? Let's unmute you, Carol. Carol, can you hear us?
I can hear you. Can you hear me?
We can hear you now. Yes.
Oh, right.
Yes.
I couldn't find. I raised my hand, but then there was no space to actually type my question.
Okay. If you go to the control panel for Zoom, which is there are some boxes there. One's got Q&A on it, and one's got chat on it.
Yeah.
And if you just type into the
chat,
into the chat, it should appear up on my screen.
Okay. Thank you.
All right.
No, I can't do it. I can't type in the chat box.
So okay. Have you got a Q&A box there you can use?
Hang on. Q&A. Answer. No, I don't want to answer that question. I want to answer a new question.
Okay, I'm gonna remove you as a panelist.
Yeah.
Okay, Carol, you should now be able to ask questions. So Michael had a question, Bryan,
yes.
Which was, does the inheritance trust come into effect only when the inheritance is ready to be transferred to the daughter?
Yeah, so with the inheritance trust, what we're talking about is if mum and dad pass away, under their will, they leave their estate to that trust. So whilst the trust is created by mum and dad during their lifetimes, it's effectively a shelf or a shell trust that just sits there with that initial settlement of $10 or whatever it might be, $100, whatever the initial settlement was. It sits there dormant, for want of a word, and is effectively activated when mum and dad both pass away, and it drops down the funnel from their estate into the inheritance trust at that point in time. Yes.
Right. So until that point, it's pretty much dormant.
Yeah, correct. Okay. Yes. Yep.
Okay. Ranjit mentions, has some questions that would be, I think, of importance in determining what the estate planning challenges might be. And that the question will be, how will the assets owned individually be distributed, or how are they planned to be held beyond the relationship, or beyond the marriage?
Yep, good.
And Adam's comments, quite interesting. Tread very carefully and try not to break up the relationship when touching on the estate planning issues.
And I shouldn't laugh, but yeah, we often have to have courageous conversations with clients about, because what we're talking about is the relationship going forward. But yeah, we're talking both emotional and actual, i.e., dollars and cents versus emotions in that. So quite often we tread very warily and on eggshells. Exactly. Yeah.
Okay, I think it's pretty much, it's quieting down now. So that's
right. Yep. Okay, so I've just put up now some of the issues that we see. So what effect does marriage have on a will? So from a legal perspective, if you've got clients, they're engaged, they already have existing wills, once they get married, those wills are revoked. So if you think of your clients, your client base at the moment, how many of your clients have recently got married? Have they reviewed their will post their marriage? Because if they haven't, potentially they now don't have a will, and therefore the rules of intestacy will apply, whereby based on their circumstances, the law will dictate how the estate is to be distributed. So if you can think of your clients, think of their circumstances. Have they recently got married? Have they reviewed their will? Ownership of assets, we mentioned in the example that they have assets both owned individually and jointly. So, and again, this is coming back to your previous question, or the question that was raised, David. What do they want going forward? Is it appropriate for the assets still to be owned individually? It may be that they do want to have the assets owned individually. So therefore, how do they protect those individual assets? That's when you're looking at a Section 21 contracting out agreement, whereby both parties will need to go off, get independent legal advice, and acknowledge that they each have their own assets and they want to maintain the separation or the separate ownership of those assets. A formal agreement is then prepared and drawn up and signed. That agreement needs to be witnessed by a solicitor, and that solicitor has to be independent of each party. So Bill gets his solicitor, Mary gets her solicitor. The downside of that being, of course, is that what basis is that for a new marriage? And that, yes, Mary, yes, Bill, we love each other, but before we go any further, we need this agreement signed.
But we don't trust you. Yeah.
But we don't trust you. Yeah. Courageous conversation. Yeah. Yeah. The next point, the potential inheritances. Both Bill and Mary have elderly parents. Do they want their inheritances to come into the pot of the joint assets, or do they want the separate assets to be retained? So Bill wants his parents to leave his inheritance to him via an inheritance trust. Mary wants her inheritances to go to her via an inheritance trust. Or are they happy that that does go into the Bill and Mary pot? And then we have the Property Relationship Act issue, which is the situation around the presumption of a 50-50 split of assets in the event of separation. So those inheritances will become relationship property in that. So just from an overview, these are the issues that I see, or we would see from an estate planning point of view. Were there any others that you had received through from any participants, David, that you want to share or comment on?
No, there was no other questions came through. We've covered off the all of them, so thank you.
Yeah, so as far as solutions, and as I've just talked to, they need to look at wills unless their wills were made whilst they were engaged and had a specific clause in them which says that the will take effect whether or not the marriage takes effect. So what we call this is the contemplation of marriage clause, which says that Bill and Mary are both engaged to each other. They're doing the wills on the basis that the wills will be effective whether or not the marriage takes effect. So what that means is that if they do get married, it's a valid will. If they don't get married, it's a valid will. So it covers both scenarios.
Carol made an interesting point. People need to be aware that if their parents go into care, this house and other assets will most likely be gobbled up by winds.
Potentially, yes.
Yeah.
Yep, exactly. Yep. And that's another conversation, another debate as to the appropriateness of MSD and the residential subsidy situation and what's the best way to avoid it, or is there a good way to avoid it, or probably more importantly, can you avoid the residential care situation? And certainly as a quick overview, MSD are being very, these are my words, ruthless and thorough in investigating clients or people that are going into residential care and whether they have disposed of or deprived themselves of assets, and therefore when they apply for residential care subsidy, do they deem that they have done this deliberately to entitle themselves to a benefit? But that's probably a topic for another session, David.
Yes, I think you're right.
Yeah.
Yeah.
Okay, other potential solutions, they should look at separate trusts or inheritance trusts so that they have individual assets. It may be appropriate that they set up separate trusts so that their individual assets go into their individual trusts, or that their respective parents set up respective inheritance trusts so that when the respective parent or parents pass away, it goes into that inheritance trust for Bill or for Mary and doesn't go into that joint pot of relationship assets in that. Clearly, they need to review the ownership of their assets, and I'm not saying that it's not appropriate to have individual and joint assets, but are they comfortable? Are they aware? Do they want to maintain both the joint assets and separate assets, or what do they want going forward? So have they reviewed the appropriateness of both their joint and individual assets? And clearly, the enduring powers of attorney, not only for each of them, but for their elderly parents as well. So again, yeah, and I know I may sound like a bit of a stuck record. It's not about the advisor telling the clients these things, but being aware that from a client's perspective, these things could potentially happen. So as the advisor, this is where you add real value in saying to your clients, hey, these are your circumstances now. Okay, this is the life journey that you're on. Potentially there are issues around here. You do need proper advice, or you need to have advice.
John, you've raised a point. I'm not sure I understand the context of the point. It looks like the question might have been cut off in terms of number of characters. So in the event of a breakdown of a relationship, does the outgoing partner have any claim against the trust? So this is going back to, so he gave a bit of background. There's asset ownership inter vivus trust established 20 years ago. De facto relationship starts 16 years later.
Yes.
No partnership property agreement signed. In the event of a breakdown relationship, does the outgoing partner have any claim against the trust?
Yeah. Okay. Yep. No, I can understand where they're coming from. And what he's saying is that, okay, I'll use me as an example for argument's sake. 20 years ago, I established my trust. I put my family home or my home into the trust. I then met my partner 4 years later. I have been in that relationship with the partner for now 16 years. So there's a 20 years from when I met my partner to the time our relationship ends. What claim does she have on my trust? I think that's what.
Yeah, I think that exactly. I think that's right. Yeah.
Yeah. Yeah. So potentially, yes, there was a claim against the trust on the basis that that partner could have contributed to the upkeep of the property. She or he may have put funds into the upgrading of the property. They may have put in a new swimming pool, put in a new entertainment area, contributed from a financial perspective, which has increased the value of that property. Potentially, that increase or capital gain during the period of the relationship could be claimed to be relationship property. So there is a potential there that the partner could get a claim or have a claim against the value or the increased value of that property. So it's always, yeah. Okay, so, and I'm aware that as per normal, I talk too much and I've got 15 minutes. So if we then look at the third situation, so your client was single, has got married, now has children. So again, briefly the facts, your client has a child born of their current relationship. They also have a child or children of previous relationship. They also have a child who was legally adopted out prior to the relationship. And they also have a child who has physical and mental health issues. So again, what we're talking about here is that this is your client who has presented to you for their review. You are now aware, or it could be a new client, for example, of this background. So again, from an estate planning point of view, what issues, what thoughts do you have around estate planning challenges or what the client should be looking at? So again, if you could just flick through to David, questions or thoughts via the chat box or the question and answers as to what red flags, what issues, what potential problems there might be for this client of yours whose circumstances are on the screen, and that they have a child of the current relationship, child of the previous relationship, a child who has been adopted out, and also has a child who has the special circumstances.
So a child's been adopted out, they had, the child was theirs but was adopted out to somebody else, or have they taken on an adopted child?
we can use both examples or both scenarios, but if you look at the child who they have had, but they have now had that child legally adopted out. So, for example, if I had a child from a previous relationship and I have then given that child up, or sorry, both parents have then given that child up, because both parents have to agree, that child is given up for adoption, and a formal adoption has taken effect.
Okay, so that's an interesting scenario, isn't it? So
Yeah.
what challenges does that present? Where are the risks? What are the in the event that something happens to the parents?
That's right, exactly. Yep. Okay, so should I just go through to the issues identified, David? Because I'm sorry, aware of time.
Yeah, we are. Yeah, we've got about 13 minutes here. Probably got another couple to go, haven't we? So.
Yep. Okay, so what we're looking at here is what the equity of it. What is equitable? What is fair? Is it appropriate to treat all children equally? From a legal perspective, do you have to treat all children equally? What are the requirements with respect to the child who has greater needs, who has the physical or mental health issues? What about guardianship? If both parents pass away, who's going to look after little Mary or little Jimmy? That last bullet point, what age would the client want the children to inherit? So these are the sort of things that clients, when we talk with them about children or about their circumstances and what they see for the children, these are the topics that they raise with us. So from a solution point of view, if we look at the age of inheritance first, unless the will maker stipulates otherwise, there's an automatic age of inheritance of 20. So if you don't nominate an age, the beneficiaries under your will receive their inheritance at the age of 20. With due respect, and I can talk from personal experience, fortunately or unfortunately, as I often refer to it, if I had have received an inheritance at the age of 20, what would I have done with it? I suggest, and although I say it jokingly, I somewhat think remorsefully, if I had have, it would have been a good time, not a long time. So how would your clients feel if their estates were to pass to their children or to their beneficiaries at the age of 20? Appointment of guardians. If both parents pass away, who is going to step in to be the guardians? Because unless there's a will, there's that uncertainty, or if it's not covered under the will, which family looks after the children? Who steps in to provide that guardianship? With respect to the provision for different classes of children, so we talked before about the child, and I'll just bring it back up, the child that has special needs. Should there be a greater provision for that child? The child that is adopted out, what is the legal requirement to provide for a child who has been adopted out? From a legal perspective, there is no requirement to provide for that child because that child is no longer deemed to be the natural child of its birth parents. So what the situation is there, if I adopt my child out, I legally have no obligation to provide for that child, and conversely, that child has no legal claim against my estate.
That's what Brent was saying, yes.
Yeah.
Okay.
Yep, cool. Okay, and then if we look at that child that has special circumstances, what is appropriate? Should there be a trust created for that child during his or her lifetime by the parents, and potentially that trust could hold a life insurance policy which could be greater than the value of the other assets, so that that policy is owned by the trustees of that trust. It, for argument's sake, could be worth $1 million. The assets of mum and or dad could only be $500,000. They're held under their estate via their will. So their other children get $500,000. The one with the special provisions gets $1 million. Is that fair? Is that equitable? Can that be challenged? No. On the basis that the trust is a separate legal arrangement, it's not part of the estate of that deceased person. Whilst the will can be challenged, and we've talked previously about the Family Protection Act and the Property Relationship Act, the trust won't be able to be challenged on the basis that that policy is held there by the trustees for the benefit of that child with those special circumstance or situation.
Yeah, Adam's made a point there, which I think is probably along those lines. Surely in these circumstances, the trust would be the most suitable solution.
Yeah.
Otherwise, will contention could send funds to lawyers, which is a fair point.
And I mentioned there about a protective trust pursuant to a will. What we're talking about here is a trust that's not an inter vivos trust, or not a trust that's created pursuant during the lifetime, but it's a trust that's created pursuant to the will. So, for example, the client creates the protective trust so that that child with the special requirements, their share of the estate is held in trust under the will for their maintenance, education, advancement, or benefit. It's not held by the individual, by that child. Therefore, it can't be assessed for asset testing purposes, for WINS benefit purposes. So it's protected for that child, and also protected against any potential caregivers, or as I often refer to them, as caretakers, who unfortunately abuse people from a financial perspective, so that that child share is held under the will and is available for them during their lifetime, and then in the event of their passing would go to their other siblings or other next of kin. Okay, so if we quickly move on to our client who's got married, was a single person, got married, had children, but unfortunately has now got divorced. So again, just the circumstances, client has recently got divorced, they have assets that they held both jointly and individually, has a current will made when they were married. They have not reviewed that since their divorce or separation, and at present they have wills in favour of their former spouse. So again, this is your client presented to you with the change of circumstances. What, from an estate planning perspective, are the potential issues or circumstances that they should be aware of or need to be made aware of that would require them to review their estate planning circumstances. So rather than get you all to send questions through to David, if you're happy, David, I might just skip on to the potential issues that we've identified. Is that okay?
I think so. Yes, I think so. We got 6 minutes, so yeah, we should. We should.
Yep.
Move through. Yeah.
Okay, so clearly, from a will perspective, what is the effect of divorce or separation on a will? So divorce does not revoke the will itself. It revokes the provision for that former spouse or partner. So for example, if I get divorced or legally separated from my wife, my will is still effective, but what happens is that the provision for that former spouse is revoked, and it then drops down to the next level of beneficiary. So by way of example, the situation that I have dealt with, whereby the client, when he made his will, was happily married, left under his will the estate to his wife. If the wife predeceased him, because they had no children themselves, the estate went to the wife's mother. Unfortunately, at the time of his death, he was divorced. He had not revoked the will. So the will stood on the basis that it left it to the wife, but because they were divorced, that provision was removed. It then dropped down to the next level of beneficiary, which was the ex-wife's mother. So the ex-mother-in-law inherited the estate. So divorce and legal separation revokes the provision for that former spouse, but not the will itself. So again, what has happened to your clients? Have they gone through a divorce or a legal separation? If the separation is of an informal basis, i.e. there's no formal agreement, then that separation has no effect on the will, so that the former spouse will still take as the beneficiary. So what we're talking about is the appropriateness of the will, the appropriateness of the EPA. So again, it's about review, it's about noting or ensuring that as a result of the change of circumstances, the change of situation, that the estate planning has been reviewed. So clearly, we're looking at new wills, new enduring powers of attorney, and revocation of the old documents, because whilst marriage will revoke the provision for the former spouse, and enduring power of attorney is not revoked on the same basis, so that the client might think that they've got divorced, so they've tethered or severed all ties with their former spouse. Unfortunately, the enduring power of attorney would still be in play, so potentially there is the risk that that former spouse, if they are of the desire or intention to do so, could still potentially have access or authority with respect to their former spouse or partner. Okay, sorry, David. So the next example, and I think because of time, we may just have to postpone that one, but because we've only got a couple of minutes, is it appropriate to have questions, comments, or anything that you've got there that has been raised?
No, there was Adam raised a point. It goes back to the one about the trust with the children, and wondered whether, in fact, there was any significant will issues, and in fact, perhaps the trust would resolve all of the issues rather than putting wills in place to try.
Yeah, well, I suppose it depends on the children. So, I'll just quickly go back to the children's circumstance. So, yeah, potentially you could have a trust for all of the assets, and under that trust you could be disproportionate or have a memorandum of wishes which says the priority is the child with the physical and mental health issues, then the child of the current relationship, then the child of the previous relationship. So you could almost have a tiered level of beneficiary in the trust under your memorandum of wishes. Yes, you could have one trust for the child with the special issues, which is fully for that child, then another trust for the other children, or you could have multiple trusts for the multiple children. So it depends on what's appropriate. But again, what is the client's objective? What are they trying to achieve? What is their desired outcome, basically? But and options there.
Yes, that's right. So, but I think that at least from the point of view of the child with physical and mental health, I think the trust is the way to go, isn't it?
Yeah, definitely. Yes. Yeah.
Okay. Mm-hmm. No other specific questions. We'll give it a second or so as we wrap up. So if you've got any more questions, feel free to throw them at us through the chat box or the question and answer. Bryan, a really interesting presentation this morning. Thank you. I got a lot out of it. I learned quite a lot. I hope you in the audience were able to take some value out of what Bryan has shared with us this morning. What it tells me is that there's a whole lot of stuff out there that we just need to be on top of and aware of. As you say, it's not a case of us being experts in estate planning. It is really understanding some of the technicalities and issues that could give rise to estate planning issues that need to be considered when advising clients on risk or mortgages or investments. And in fact, I mean, I see estate planning as very much a form of risk management for the client, because it's a form of asset protection. And protecting the needs of the beneficiary. So, one question: Did the mother-in-law get the money because the person's own parents had passed away?
No, the mother-in-law got the money because she was the beneficiary of the will. The will maker, when he made his will, didn't include his parents, and legally he had no obligation to do so, because at that time, and it's always in hindsight, it's a wonderful thing, at the time he did love his mother-in-law, and there was a good relationship. That was prior to the breakup of his marriage and relationship. Yeah. So, and that's an interesting point, because the deceased parents couldn't contest the will because he had no legal obligation to provide for them. Yeah.
Yeah. Interesting, isn't it?
Yeah.
Okay. Bryan, thank you again for your time this morning and you sharing your insights. I hope you found this valuable. And thank you to the audience for joining us this morning. I hope you found that was valuable use of your time on a Friday morning. Have a very, very good weekend. You'll get an email over the weekend with a link to the online survey. So if you want to take advantage of the structured CPD, then you'll need to complete that. I will also post a video from this session up onto our YouTube channel. If you haven't subscribed to that, I would encourage you to do so. Just search for NZFAA. Have a great weekend. Bryan, thanks again, and we'll see you next time.
Thank you very much, and thanks everybody for participating.
Thank you.